Hello, good evening. This is Ms. Chaudhary, immigration attorney from Ms. Chaudhary and Associates Immigration Law Firm. Today is April 3rd, 2020, and I'm in front of you updating you about some of the notifications which we have received from the Department of Homeland Security with regards to the request for evidence, which we mention as RFE and NOIDs. NOIDs is a notice of the intent to deny. Department of Homeland Security has notified that if the applicants or the petitioners have received the request for evidence of the notice of the intent to deny with the date on it starting from March 1st till May 1st, they will be giving the time period of 60 days grace period given starting from the deadline or up till the deadline. They will be given 60 days. If the response is received within the 60 days grace period, it will be considered as timely filed and it will be considered by the Department of Homeland Security to take action on that. I think so it's very important to know that they are not saying by any means, do not mistake it as, oh, we are not supposed to respond to that. You have to respond to the request for evidence and you have to respond to the notice of intent to deny, but they are giving you a 60 days grace period if the date on your notice is between March 1st to May 1st. They will be giving you 60 days, and if the response is filed within that 60 days grace period, they will be considering it even if the deadline is not followed. So this is a very important notification, but please keep this in mind. You have to respond to those, otherwise they will deny the case or they will close the case. Furthermore, as I mentioned earlier also, if you are in United States on any status, non-immigrant status, on a visit visa, you are here on immigrant visa where you need to have an extension, or you need to apply for the change of status, or you need to apply for the extension of stay, kindly do so. Immigration offices are working internally, so they are not taking the in-person appointments, but they are working on your cases. Furthermore, Department of Homeland Security has mentioned particularly the work authorization applications. The candidates who have applied or applicants who have applied for the work authorization, they are working on the work authorization applications. The people who have applied for the extension of the work authorization, that means that they already have the work authorization and they are applying for the extension, their biometrics will be waived if they have been previously done the biometrics and they are in the Department of Homeland Security system. I hope so this information is very informative to you, and you will understand the importance of filing the immigration paperwork in a timely manner. And if your extension or change of status is due or adjustment is due, kindly do so